I would also like to introduce a good friend of mine, Dr. Eddy Marek Lex. So, Pa Eddy Lex, I've known him for more than 20 years. The first time I met him was in a Dutch language course in Erasmus at Erasmus. So, but Dr. Eddy is a very diligent person because I only survived one course and I didn't continue, but he continues till the end. So the second speaker, Dr. Eddy Marek Lex, is the founder and managing partner of Leks&Co law firm here in Indonesia, and one of Indonesia's leading practitioners in real estate construction and dispute resolution. Dr. Eddy, just like I told you guys before that he's very diligent, he has 4 degrees, including a Master of Law from the University of London and also a PhD in law. He is recommended by Chambers, Legal 500, Asialaw, and has been listed as one of Indonesia's top 100 lawyers by Asia Business Law Journal for 5 years running. He's a registered arbitrator at BANI and also the Singapore Institute of Arbitrators, and a fellow of both the Chartered Institute of Arbitrators and CIArb. He has also written for major international publishers on construction law and arbitration. Given his deep involvement in the Indonesian infrastructure and construction disputes, I believe Dr. Eddy Lex will provide valuable practical insights from the local and also regional perspective. Please, Dr. Eddy Lex, the floor is yours. Thank you.
So thank you very much, Ibu Fitri. Thank you, BIAMC, for giving me the opportunity to speak today. Thank you, Prof. Inba, for the presentation. There are several points that I believe will overlap with what Prof. Inba just mentioned, but hopefully my points can complement what Prof. Inba just mentioned. Okay, these are the points of discussions. I will start with the causes of dispute in the construction sector, and then moving forward on the arbitration versus litigation, which one is better and why is it? And then going forward on the tier dispute resolution, I will try to introduce some of the models on how the dispute resolution clause can be structured. And then I will also touch on the domestic arbitral award meaning versus the international arbitral award, especially in relation to the recent constitutional court consideration and decision. And then also touching up what just Professor Inba already mentioned about drafting arbitration clauses, factors to consider when we have and we want to draft arbitration clauses, especially in the construction sector. And then I'm a registered arbitrator in BANI, and I'm quite familiar with the BANI rules. So I would also like to share some of the new rules of BANI institution, yes, especially related to the construction dispute. Okay, so the causes of dispute are so many. These are just examples. One is the macroeconomic volatility. We understand about the tariffs war, and then we also have wars happening, and that disrupts and that causes surge in prices, and this may affect or may influence the tribunals where there are disputes brought into the arbitration, whether these events will be considered as force majeure or simply commercial risk the contractor must bear, because normally this increase of cost will be borne by the contractor. But of course, it will depend on how the construction contract is also drafted and regulated between the parties. The other causes of dispute is the technical and design deficiencies. The project has to be completed very fast, and perhaps there has not been a complete design yet. So many mega projects break ground before designs are finalized, and this may lead to mid-change projects and quantum claims. And this also results in the financial issues, between the contractors and project owners. There is also a cost overruns disputes happening at this moment, according to the news, between WICA, a publicly listed company, a contractor, state-owned enterprise, versus PT Kereta Cepat Indonesia China at the SIAC, seeking approximately 5 trillion rupiah. So cost overruns is one of the causes of disputes, and payment delays normally from the project owner may trigger delay damages and of course disrupt the contractor's work performance. And the other issues that is quite normal is the liquidation of bank guarantee. When the contractor is deemed to have defaulted the contract, and then the project owner will liquidate the bank guarantee, but there are several issues related to that liquidation, whether the default is really occurring, whether the bank guarantee can be liquidated irrevocably without any conditions, or even whether there are any losses that can be proven before the liquidation is conducted. So these are the factors that can happen when the dispute arises in the construction sector. And of course, the contractual and legal ambiguities, how the clauses are structured, how the scopes of the contractor is regulated, how the bill of quantities is agreed. And it may happen that the contractor thinks an item in the bill of quantities is an extra, but the owner claims it is as inclusive. And then the dispute will arise between the two parties. And also performance delay, issues regarding work performance completion, whether the contractor has fully completed its obligation as per contract. And sometimes this is argued back with the substantial performance, because the full or perfect performance is not possible, for example, or differing site conditions, what has been inspected in the beginning or may not be inspected very well in the beginning, then found very different when the contract is performed by the contractor, for example, and or the late delivery of the site, and various issues related to the land procurement. Sometimes the land procurement is problematic, has not been fully completed. And in Indonesia, especially in the remote areas, there might be relevant that the community, the community in the respected areas, having some ceremony even before the land procurement is considered as completed. So that may also delay the site delivery. So after discussing about the causes of disputes, Professor Inba also touched this. So why do we even consider the arbitration when we compare it to the litigation? So from the expertise feature, we consider that in the arbitration, the parties can select the arbitrators. They can nominate, especially when the tribunal consists of 3 arbitrators. When it is only 1 arbitrator, of course, it is either agreed by the parties or it is designated by the chairman of institutional rules, agreed by the parties, or even by the other institution selected by the parties. But this expertise is very important, I believe, in in having the reason why we choose arbitration instead of litigation. While in the litigation, judges are generalists, yeah, normally generalists, and may not understand the complex technical construction terminologies. Particularly also when it is related to the several forms of contract, standard form of contract that is relevant in the construction sector. And of course, confidentiality is paramount. Professor Inba has touched this issue, reminding us that different jurisdiction, different confidentiality, perhaps different seat, different governing law has treated differently on the confidentiality. And Indonesia is still learning also in this sector, and we may not see many courts decisions giving rules about the confidentiality and privacy on arbitration dispute. But generally speaking, of course, in the arbitration, it is confidential. We have the legal norm in the arbitration law of Indonesia that the proceedings are private, and the arbitration award is not published. So the public cannot just obtain the arbitration award even when it is registered in the public court. While from the litigation perspective, it is publicly available. We can obtain the decision easily, seeing how the legal arguments were made and also the evidence is submitted. And in terms of enforceability, this is related to the International Arbitration Project, of course. We have the New York Convention, one of the most successful convention in the world. Indonesia is part of it with the reciprocal principle. While if we have a foreign court decision, Indonesian law does not recognize it. So it cannot be enforced in Indonesia territory. So it has to be repeated. So it has to be reclaimed in Indonesian court. And of course, the finality, arbitral award is final and binding. We can immediately execute the award. While in the litigation perspective, we have a district court, we have an appeal court until Supreme Court in the cassation level. So going forward to the tier dispute resolution, in the construction disputes, we understand that it can be very complex. Sometimes it can be decided easily through dispute adjudication board, for example. But sometimes, or most of the times, it cannot be easily resolved by the parties. So multi-tier or multi-level resolution might be more feasible before the parties refer to immediately refer to the arbitration, for example, or to the litigation. So negotiation is always the basic phase, yeah, a discussion between parties to reach a mutual agreement. And of course, when the negotiation fails, the parties can also engage with a mediator, a third party, and we have so many different types of mediation. A more active mediator, passive mediator, or even an expert mediator to be involved and to help and facilitate the discussion between the parties to resolve the dispute. So even though it is not always the case, but engaging a mediator may help the parties to see the dispute objectively, clearly, and then be resolved. And of course, if mediation also fails, then any party can refer to the arbitration. Or we can also just use the negotiation and arbitration. I think this is perhaps the most common the resolution of dispute clause. So when a negotiation fails, then any party can refer immediately to the arbitration. The other is the negotiation or mediation, and then involving dispute adjudication board. This is increasingly used by the parties in the construction agreement. And we can see Prof. Inba also mentioned about this, that the FIDIC is using it as the standard form. But my experience is not every time the parties in the construction agreement will normally use this board. Yeah, because in my experience, it is quite many that the parties do not like this dispute adjudication board. They just want immediately to go to the arbitration or litigation, but most of the time it is arbitration. But of course, dispute adjudication board can be activated. It is more cost efficient, should be, than the arbitration. It should be faster, and if the matter is resolved, then the contract can proceed. The parties can still proceed without having a dispute prolonged. And of course, the dispute adjudication board decision can still be challenged. And if it is still challenged, then that the party will resolve the matter in the arbitration. The other two is MedArb, mediation, arbitration, and arbitration, mediation, and then ruling. So of course, I believe in the many institutional arbitration rules, they have a MedArb clauses in their rules. So this can also be used by the parties. But of course, the best is to have it in the resolution dispute clause in the agreement. So it is compulsory by the parties when they are having a dispute and one party filing a claim in the arbitration. The arbitration proceeding will not commence before the mediation takes place. And once the mediation fails, then the arbitration proceeding can proceed. So there is a downside, of course, and the strength for these clauses, because the downside is the arbitrator will have a dual role, which may not be good, because the arbitrator will be the mediator and then becomes the arbitrator. While in the ARB-MED, there will be arbitration first, immediately. So the arbitration proceeding will take place immediately, and then the parties will argue in the arbitration proceeding until it is awarded. But then the award will be closed in the sealed envelope, and then the arbitrator will become the mediator, try to mediate the dispute between the parties. And when the mediation is successful, the award will not be disclosed, will be considered as forfeited, and then that's it. It is consensus agreement, settlement agreement. But of course, if the mediation fails, the award in the sealed envelope will be opened, and then the parties there will be a winner and there will be a loser of the case. So this is the arbitration mediation ruling. So I proceed with regards to the award, arbitral award in Indonesia. So we have a domestic arbitral award. It's a decision rendered by an arbitration institution or sole arbitrator within the territory of jurisdiction of Indonesia. So Indonesian law essentially adopts a territorial principle. So this is related to the seat of the arbitration that Prof. Inba also mentioned. So for domestic arbitration, everything decided in Indonesia jurisdiction, that is considered as a domestic award. When declaring exequatur, the chairman of the court does not examine the reason or consideration of the award. But the territorial principle is not absolute. So if we look into the international arbitral award, it is just a contrario understanding of the territorial principle. So either within or without. When it is outside the jurisdiction of Indonesia, it is considered as international arbitral award. But it is also mentioned, or an award recognized under Indonesian law as an international arbitral award. So this second sentence is raising questions because it becomes unclear, especially when the seat is agreed as Indonesia, but the rules may refer to the foreign institutional rules, then what will happen with the arbitral award, whether it is considered as domestic award or international award? And in some jurisprudences, it is considered as international award, even though it is seated in Indonesia. So with regards to the meaning of international arbitral award, I would like to share the Constitutional Court recent decision. Simply speaking, or shortly speaking, the Constitutional Court does not change the substance of the meaning of international arbitral award, but it removes the word deemed or dianggap sebagai, ya, in Indonesian language, deemed as. It is removed because the court considers that the phrase deemed opens broad interpretation possibilities and potentially causes multiple interpretation and legal uncertainty. But even though, in my view, even though it is removed, the understanding is still the same. So international arbitral award is an award issued outside the jurisdiction of Indonesia, or an award rendered that is according to the legal provisions, it shall be considered as an international arbitral award. Okay, I'm moving to the factors to consider when drafting arbitration clauses. Prof. Inba has made a good suggestion before that it is better, or it is best, that just refer to the model clauses. I think that is, I can agree. But of course, in some projects, some very complex agreement, very complex projects, there may be necessary to have a more comprehensive arbitration clauses, arbitration agreement. So these are the factors to consider, especially when it relates the foreign parties and Indonesian parties in the construction project in Indonesia. So the first is the seat and language of the arbitration. Of course, when it is the project in Indonesia, I would recommend that the seat should be in Indonesia. And the language of the proceedings, there are several factors. The contractual documentation language is one factor, but under Indonesian construction law, when there is a foreign party with Indonesian party, there must be always exist Indonesian language contract, and then supplemented with the foreign party, a foreign language contract. So it is a dual language contract, for example. But the governing language is also considered Indonesian language as the prevailing language that is regulated specifically under either under construction law or under the government regulation. And also the governing law, yeah, the construction contract should be governed by the laws of Indonesia, and then the languages spoken by the parties. So this is the language of the proceedings, because in the arbitration, we can choose which language will be used during the proceedings. It is not necessary all the time that if we arbitrate in BANI, for example, that we can always only use Indonesian language. Yeah, that can be agreed by the parties. A number of arbitrators is also a part of the choice between the parties, and this is related to the complexity of the contract. And in my experience, for construction dispute, it is advised to have 3 arbitrators rather than 1. Yeah. But of course, the cost should be also considered, because having having three and then compared to one may have impact on the cost of arbitration. So the parties can agree on the numbers of arbitrators. And the selection of arbitrators is also possible. The qualification, what qualification the arbitrator should be nominated by the parties. And then the administering organization, whether this is institutional rules or ad hoc arbitration. And then the interim relief agreement between the parties, whether the parties will regulate that anyone raising the issues in the arbitration can also request for an interim relief. And of course, in the construction, consolidation and joinder may be very relevant, because in the construction dispute, it may involve the project owner, the main contractor, and then the subcontractor. It can be specifically regulated in the contract between the project owner and the main contractor, and also between the main contractor and the subcontractor. And then we have discussed the tier dispute resolution clause. And then work continued pending arbitration. This is normal, and I see that this is also important to be regulated. Even though there is a dispute between the parties, the work should be continued. And the choice of law, it is normally under Indonesian construction law, it should be governed in Indonesia law. And of course, it should be also applicable to the arbitration agreement itself, just like what Professor Inba mentioned before. And then the last factors to consider is the currencies. What currencies agreed that can be claimed in the arbitration, and there is an Indonesian jurisprudence also that obligates to convert the foreign currency to Indonesian rupiah. And then the last thing is the highlights on BANI. I will just move quickly on this. BANI rules provide for multi-party disputes clause for claimants, more than one claimant, more than one respondents that can be regarded as claimant group and then respondent group. And then multi-contract dispute clauses that can be consolidated within one proceeding, as long as there is connection between the agreements and BANI or BANI rules is chosen as forum for a settlement. And then emergency arbitration, also touched by Professor Inba. But in Indonesia, this is actually very new. Indonesian arbitration law does not stipulate this specifically. So we should rely on what will happen in practice when anyone uses this emergency arbitration procedure. But BANI rules provides this. So there is availability of urgent relief expedited procedure, because it has to be decided prior to the constitution of the tribunal. But there is still uncertainty on the enforceability, not yet regulated under the Indonesian arbitration law, and uncertain practical application, the one that we will see later on. So that is all from me, Ibu Fitri. So I return this to you. Thank you very much.
Thank you, Dr. Eddy, for giving us a very thorough highlight, especially with respect to Indonesian arbitration. I think it's very complicated because Indonesia is more of a form over substance jurisdiction. So that's why you're very thorough in each of the assessment. Now, I think we